After further study and examination of all information given for the case Siva, Chong and Mukris, we realized that several questions come up from the case. The first question was it need for the partnership to give compensate to Siva from the additional contribute that him invest into the partnership. The first question arises because of Chong and Mukris disagree of Siva request that to compensate him as he invest more capital to partnership than what they agreed. In terms of legal application, this situation has different apply of section and application. The first situation involves the application of interest of extra capital, whereby in section 26C in Partnership Act 1961, provide that partners making for the purpose of the partnership any actual payment of advance beyond the amount of capital which is agreed to as subscribed is entitled to 8% interest per annum from the date of payment or advance. This means that the additional amount that has exceeded the agreed amount of capital will be categorized as loan from the partner that give the additional capital and not as an increase of his contribution to the capital. For the example, the partnership has 3 members which is A, B and C that will inject the capital to their partnership. All the members have agreed that the amount to be invested in the partnership is 100,000 and they should mutually divide profit and liability. Over the year, C decide and agree to himself to invest more to the partnership as the business are started to grow. The action of C is considered as loan to the partnership and they need to pay the interest towards C even if the A and B doesn't agree in action of C. Firstly, in this case, Siva have contributed in an extra capital to the partnership as the company earning increased over the year. After that, Siva asked for the compensation because he had contributed more capital in the partnership, which is Chong and Mukris do not agree with that statement. Because they felt there was no need to pay Siva for his additional contribution. Siva himself also have agreed to invest more capital into the partnership, which the additional capital by Siva can be assumed as a loan and not as his contribution to the to capital. From that situation, we can see if that Siva wants to claim his money back, he will and he can. But if he want to claim for the interest of loan from that money, he cannot because from the beginning, his partner, which are Chong and Mukris, do not have give a consent for Siva to give the partnership or firm the additional money. For the conclusion, in this issue, Siva may be entitled to recover his additional contribution. However, in order to avoid potential future dispute, it is strongly recommended that Chong and Mukris need to pay back the additional capital that contribute from Siva.
Next, for the issues number 2 is operating new business that offering the same interior design breach any legal law of partnership. So the second question come out after Siva open a new business that offering the same interior design service for their partnership business, which is this can compete against each other. Next, for Section 32 of Partnership Act 1961 states that if a partner without the consent of the other partners carries on any business of the same nature as and competing with that of the firm, he must account for and pay over to all firm all profits made by him in that business. This section explanation is about a partner who runs a private business will be liable to account to his co-partners for the profits that he makes from such business. This section only applies to the business that runs the same nature and competing with the partnership business. In the case of us versus Benham, the defendant was a partner in H. Clarkson and Co., where he had to assisted in information for building a ship. Later, he decided to be engaged in another business as a ship owner and wanted to use H. Clarkson and Co. ship owning as the business name. The plaintiff brought an action to restrain defendant from using business name and claim for the account for his profit and salary in the new business. Court held that the defendant cannot use the partnership business, but as the new company it is not the same nature and not have to account for the benefit or profit obtained by him in the new business. Okay, next. In this situation, Siva opened his new company which he made a few mistakes that made Chong and Mukris fell dupe when they learned this. For the first one, Siva had opened the business that have the same nature with his old partners from Chong and Mukris. Secondly, we also can assume that Siva had opened his new company near to the location of that partnerships. Moreover, Siva did two of those things without any concern from two of his partners, that are Chong and Mukris. This situation may impact the firm to get a lower profit from before, because they have to compete with a new competitor, which is new Siva's company. Siva's act has caused Chong and Mukris feel betrayed and cheated by him, where they are not satisfied and want a justice for them. They held that partners should not compete with one another in a business partnership, and that mutual understanding is essential. Based on that, Siva must account for and pay over to the firm all profits made by him in that business. Okay, so for the conclusion, for the second issue is Siva had opened the new company which is have a same nature with his old new company with Chong and Mukris, and also the new company is near with the old company. So therefore, which is this can constituting to breach of partnership agreement, their partnership agreement. Therefore, Siva had to give all the profits that he earned from his new business to the Chong and Mukris.
Now we go to the last issue in this session is Siva who keep making a problem to the partnership. Is there any ways to resolve it? This issue arises because of Siva keep committed to breach a partnership. Okay, according to section 37D in partnership 1961, when a partner willfully commit a breach of the partnership agreement or otherwise so conduct himself in matters so relating to the partnership business, that is not reasonable practicable for the other partners or partners to carry on the business into partnership with him. This application applies when a partner presently breach the partnership agreement, that it will be impact the partnership. As the case example Cheeseman vs. Price 1965. In this case, partner who manage the responsibility of the bookkeeping has made a facility mistake. The partner has not entered the receipt the account of a company, even though this matter is small, but this matter repeatedly 70 times, and the court held such a behavior can allow the partnership to dissolve it. That's all. For the application for the situation is given is Siva, one of the partners in the partnership, has made a few mistakes that give a big effect for the firm. Two situations that show mistake from Siva are he stopped give a full disclosure and negotiate when dealing with a client without a consent of a Chong and Mukris. This lack of the collaboration lead to increase the frustration and Chong Mukris as they will longer be able to achieve a mutual understanding with Siva as their partners. This issue because of Siva need to gain consent and other decision from other partners in dealing a business with a client. Second situation is Siva opened a new business offering the same interior design service from his partner with a Chong and Mukris. This action from Siva also did not have a consent from his other partners, and for this situation causing a leading financial losses for their business. The conclusion for the issue is the court may dissolve the partnership if a certain conditions are met. Our recommendation for the other partner is need to apply this case to the court or dissolve the partnership. That's all for us. Thank you.